Okay, I'm going to go ahead and start. The rest of the people will have to catch up with us. We're going to continue on through the contract today. I believe we're on paragraph 18. Wood destroying insect inspection. Please note that it's not termite inspection. It's all wood destroying insects. I'm sure we all still refer to it as the termite, but it covers those bees, those pesky bees and everything else that bore into wood. So they added to choice none, because if it's a cash deal and you don't want one, then you shouldn't have had to make a choice between the two. So option is none. If the lender does not require it for one on the 18th floor of a condo building, then we would use none. But your choices are buyer at buyer's expense or seller at seller's expense will furnish a written report from a pest control firm dated not more than 90 days prior to settlement, showing that all dwellings and/or garages within the property, excluding fences or shrubs, not abutting garages or dwellings, are free of visible evidence of live wood destroying insects and free from visible damage. Let's take a look at that. If you're a buyer's agent, who should be paying for this expense? Well, a lot of buyer agents think, well, we're saving $50 by letting them tell the seller to do it. But I prefer the buyer choose the termite inspection company, wood destroying insect inspection company, because for $50 or whatever it costs, we get the report, we know if there's any damage. I mean, if you allow the seller to do it, the seller gets one report and they don't like it, then they go back and they'll order another one until they find one that they like, and then they'll give it to you. I'm flat out just going to say to the buyer, this is one of those fees we pick up, okay? Unless it's a VA contract, a VA purchaser cannot pay for the termite inspection, which is another one of those little things that I do not understand VA's thought process, but that's what it is, okay? You also notice that it's now 90 days prior to settlement, not 30. I would prefer 30. So if I'm the buyer and I say I'm going to order the report, then I control that I can get one, within that last 30 days prior to settlement, and more current. But if you check seller at seller's expense and they had one that's less than 90 days old, then that's the one you're going to get. So I can see more reasons to say I'm going to have my buyer pay for it than I would the seller. Now, I want you to pay close attention to this last sentence in paragraph 18, especially if you're the listing agent. Any treatment and repairs for damage identified in the inspection report will be made at the seller's expense, and seller will provide written evidence of such treatment and/or repair prior to the date of settlement, which shall satisfy the requirements of this paragraph. Now, you'll notice in the sentence before, no evidence, visible evidence of live wood destroying insects, things moving around. But it also says, and free from visible damage. And in the last sentence, your seller is agreeing to pay for any visible damage, not from active termites. It could have been where they bought the property and there were no active termites, so the report said no active termites. They go ahead and buy the property. Now this next buyer comes in and there's this previous damage and they want it done, they want it fixed, and your buyer's agreeing to fix it. And there's no limit on the amount of money, okay? No limit on the amount of money. So That's kind of wide open if you're the listing agent. Now, VAR, Virginia Association of Realtors, also has contract forms that we can use. You're better off using Northern Virginia's for our market, but I want to share with you something from their termite wood destroying insect paragraph that I really like. I'm not saying that you should put it in there, but listen to this. If the inspection reveals damage to any applicable structure, seller shall have the damage repaired by a contractor licensed in the Commonwealth of Virginia, provided, however, that if the estimated aggregate cost of such treatment or repairs or both exceeds $1,000 and purchaser and seller cannot agree on how the amount exceeding $1,000 will be paid, purchaser shall have the right to, 1, accept repairs or treatment not exceeding $1,000, in which event seller shall have such repairs or treatment performed at the seller's expense. 2, to receive a credited settlement in the amount of $1,000, or 3, terminate the contract and receive a refund of the deposit. I like that language. I always recommend my seller, if there is damage to be found, that we limit the amount of dollars. Now, VAR's contract used to have a blank where they could fill in, I'm willing to pay up to X amount of dollars. Now it's just flat out 1,000, okay? So your seller would still have to fix it after if the contract kicked out, but at least now they can make a reasonable decision as to how they want to proceed or sell their property as is. And remember, one of the things you can pull out with the as is the termite clause. So I like that language. You can always go to the Virginia Association of Realtors website as a realtor licensed in Virginia. You can log on to their website. You will need to log on, you need your NERDS number, your national ID number, and you capitalize your last name, and you can have access to all VAR forms, and you can see this actual language in their contract. Now, do not try to combine forms from VAR and NVAR because you like one form better than the other, but this other one, you can't combine them because it just won't work. But I like this language where I can limit how much the seller has to pay so we can figure it into the price and how we're going to proceed. Any questions about paragraph 18? I know we had somebody had a question.
Thank you, Larry. Yes, actually, I have 2 questions. One from what you were saying about the fixes that the seller will have to do at his own expense. If in case that the seller refuses to make these fixes for the wood destroying from the inspection, would this be a breach of the contract or it would make the contract voidable?
If the seller refused to fix it?
Correct.
It would be a breach of contract, which would be, covered under paragraph 26, which we will do next week. And the breach, but the breach wouldn't happen until the day, at least 1 day prior to settlement, because it says here prior to date of settlement, this work must be done. So they have all the way up until the day before settlement to have the work done and provide the written evidence of the treatment and the repairs.
Okay, you know, so even at walkthrough, buyers might see the damage that has been caused by the wood destroying insects, and it should be okay as long as it's fixed before settlement.
Yes.
Okay. Okay. Yeah. Excellent. And Larry, the other question I had, you mentioned that if it's a VA contract, the buyer cannot pay for the wood destroying insects. Now, we had a situation in which there was a VA contract and the buyer had accepted to take care of the wood destroying insects, later on, we caught that, the buyer shouldn't be paying for that. And we spoke with the lender. The lender said it should be fine. But I just want to double check in this case, should we amend the contract? Because the contract was written that the buyer at the buyer's expense was going to pay for the wood destroying for the inspection. So in this case, should we amend, do an addendum for the contract to establish that the seller will reimburse the buyer, or we can just let it
the
go?
worst case situation there is that if it was caught, they would require reimbursement of the money. Now, if I got a VA contract in on my listing and it said the buyer would do this, and we know they can't, I would probably counter it back at that point. Call the other agent and say, double check with your lender. Are they allowing this cost, because under the VA program they can't. So I would probably counter the contract up front if I got one in on VA and they were accepting it. If the lender gave the advice that it's okay, then did the lender put that in writing to everybody?
Okay.
So
that's
so
fine.
I would get the lender. I would say fine, but would you please have your lender put something in writing that they said this is all right?
Okay.
Because
The lender.
now they're taking the responsibility for the
Absolutely.
violation.
Okay, that makes sense. Thank you so much, Larry. That was my question. Thank you.
Okay. Any other questions on paragraph 18? Okay, well, let's take a look at paragraph 19. Damage or loss to the property. Now, it would make sense that the seller has to keep the insurance on the property until settlement, correct? So why do we even have that language in this contract? Well, we're something called equitable title state. Once the seller and buyer sign a contract, okay, then technically the buyer has a beneficial interest as the purchaser. They have equitable right to that property. Now, the seller still has legal title until the money is paid and the deed is transferred. So if you've ever heard the term land contract, that's not referring to a purchase of land. It's actually an instrument where the seller holds the financing and the buyer pays payments to them. And at the end, if they haven't missed a payment, not been late, then at that point, the equitable title, they had the right to the property. The equitable title would be switched over then to a legal title and the deed recorded. So in Virginia, once that buyer has a contract ratified, if we didn't have this language, the buyer would then immediately have to take out an insurance policy to cover the property. So our paragraph 19 says the risk of damage or loss to property by fire, act of God, or other casualty remains with seller until the execution and delivery of the deed of conveyance to buyer at settlement. Okay, not recording. Okay, so it's imperative that your buyer has the insurance in effect. If it's a land contract or a cash deal at that point. Now, if I was doing a land contract as a purchaser, I'm still going to have insurance covering the property myself. But at the same time, if I was the seller, I'd probably continue to have insurance. We don't see land contracts too much in Virginia, but they are possible. Okay. Do you remember how many days the purchaser has to apply for their insurance under our contract? Well, it's
7 days.
7 days, correct?
Within 7, right.
Okay. So within 7 days of date of ratification, they need to apply for their insurance. Actually, if we didn't have paragraph 19, they would have had to take insurance out on the first day. But they have 7 days to apply, or they would be in breach of contract. And that's simply so they know how much the insurance will be, prior claims, that type of stuff. Okay, so paragraph 19 is pretty straightforward. I remember about 30 years ago, we were at the settlement table and we got a call to stop the settlement. The house was actually on fire that the people were buying. Okay, so not the kind of call you want to get at the table, but actually the people took the money, they rebuilt the property, and later the purchaser said, I still want the property. So technically, when they rebuilt the house, this contract would have given them the right to buy. So the seller has to keep the insurance on there, but there is an equitable title. If something like that happens, make sure this contract is, voided by all parties, or the buyer might be getting a brand new house if they have the correct attorney. So paragraph 19, pretty straightforward, right? So let's take a look at paragraph 20. This one here is a little bit more, this one here is a little bit more complicated. Okay, anybody have a question?
Yeah, I'm just, okay, so at settlement, let's say if by act of God something happened at the day of settlement. So the responsibility should be shared by buyer and seller, or who's in really, like after he signed, and something happens?
Well, so paragraph 19 says the seller has to keep the insurance on the property until execution and delivery of the deed. My interpretation would be, if we're sitting at the table, the seller has signed a deed, okay?
Mm-hmm. Yep.
Then and it's technically been handed to the buyer. At
Mm-hmm.
that point, the buyer better have insurance. Up until the time that deed is handed over, executed and delivered, then the seller's still liable because of paragraph 19.
But after signing, the buyer should be around.
Right.
Okay.
At that point. So they have to have their insurance paid for and in hand, and most lenders require you to get it to them well in advance now because they want to make sure. But it's those cash deals that you see that could cause a problem.
It could cause a problem. Okay. All right. Thank you.
Okay. Any other questions? Good. Well, let's take a look here at paragraph 20, title. Now this paragraph is a little bit more complicated. Okay. The title report and survey, if required, okay, cash deal, you might just say, I'm not worried about it, right? But all lenders are going to want the title report and a survey if the property is a single family home or townhouse or something like that. They might not want it in a high-rise condo, right?
Yeah.
If required, will be ordered promptly. And if not available on settlement date, then settlement date may be delayed for up to 10 business days to obtain title report and survey. Now, in paragraph 4, how many days does the buyer have to contact the title company to start all this? Do you remember?
10 days. 10 days.
Okay, that you have
10
up
days.
to 10 days to contact the title company and get this started. Look, if it's a 30-day settlement, they can't wait 10 days. They've got to get it over there quickly, right? To get all this started. But so it's the buyer's duty to get this over there, okay? But if the title work and survey are not completed, right? The settlement may be delayed for up to 10 business days to obtain title report and survey. So there's an automatic 14 days, because these are business days, right? So there's an automatic 14-day extension, up to 14 days without anything in writing if the title work is not ready, okay? Now, after which this contract, at the option of the seller, may be terminated and deposit will be refunded in full to buyer according to the terms of the deposit paragraph. Why is it the option of the seller to kill this if it's not ready and not the buyer?
Because I cannot transfer.
Well, the buyer should have ordered this in under paragraph 4 in plenty of time for this to be ready. And remember, under the statute in the state of Virginia, who has the right to select the title company?
Buyer.
Buyer. So, so now that's the situation. Who caused this default? Well,
Buyer.
the buyer, right? So it's at the option of the seller, not the buyer, but they would get their deposit back, right? Now, fee simple title to the property and everything that conveys with it will be sold free of liens except for any loans assumed by the buyer, okay? So I think everybody understands fee simple title of the property and everything conveys with it. So anything that's a fixture, right, that is attached to the property. So a fixture is basically personal property that has been physically permanently attached to the property. So, you know, if I buy fencing to put in my fence around my yard, and it's just there in a bundle, okay, and a contract comes in, the listing said I'm going to fence the yard, and the materials are there, right? And a contract comes in, it does not call for the fence, okay? Now, since all that stuff in a bundle is not a what? Fixture, it's still my personal property. Could I return all that and not put the fence up, even though it said in my listing that I would put the fence up?
Yes.
You have
Yes.
to put the fence up.
I do not have to put the fence up
Oh,
because the contract did not call for me to put the fence up. So there's a difference between what conveys with a property and does not. So until I put the fence up, now once I put those posts in the ground and I nail that fencing to it, now that's a fixture. So here's the point. If you're the buyer's agent and the listing says the seller will do something, okay, and you do not write that in your sales contract that the seller will construct the fence, okay, then the seller doesn't have to do it. It makes no difference what the listing says, okay? The listing is for informational purposes only. You can't drop the ball here, buyer's agents. Whatever that buyer wants, it has to be written in this contract. If it's already up, they can't take the fence down and take it with them. It's permanently attached. Any questions about that?
Larry, they also
Yes.
got the shrubbery, right?
The shrubbery is fructus naturalis. It stays with the property. Okay. So if there's some bushes that you've been given by your kids for your anniversaries, Father's Day, Mother's Day, whatever, and you want to take them with you, you need to dig them up, put them in a pot. Okay. When they're in a pot, they're not permanently attached, right? You can't dig up plants and take them afterwards unless it's written in the contract that you will remove those plants. Okay, so what about the materials to finish a basement? And the listing says the seller will finish the basement, but you don't write it in your contract. And they send everything back to Home Depot and get their money back. And then after you do your walkthrough, you say, wait a minute, you didn't finish the basement. And they're going to say, well, the only reason we took your price is because you didn't ask us to finish the basement. If you would have put in the contract we had to finish the basement, we would have countered your price. What are you going to do to them? Nothing. I'm going to sue you. Go right ahead. Okay. I mean, fee simple, free of, of everything, but whatever comes with that property, conveys with it, has to be a fixture. You might remember in paragraph 10, when we looked at paragraph 10, electronic mounted, wall mounted, anything that's electronic attached to the wall, like a TV, okay? I take the TV, but I have to leave the what?
The mounting.
The mounts, because the
Yeah.
mounts fixtures. They're, once you attach them to the wall, they are a fixture, okay?
Mhm.
So if I, as a seller, want to take my mount with me as well as my TV, I have to put in the contract that I am taking the mount with me, because that had now been permanently attached. Another example of case we had, the fans
Chandelier.
were there, the new fans were there, but they were never, you know, installed. The person
Mhm.
returned the fans because they didn't ask for them. Okay, they're still personal property while they're in the box until I hang them. Once I hang them, they are a fixture. One of the big arguments we run into, you may have had it, when they put mirrors in the bathroom. Okay, how was the mirror attached? Okay, if it was just hanging on a, if it was just hanging, you know, with wire on a, you know, a mount, you know, then not a mount, but you understand what I'm saying. The
Mhm.
but put a nail in the wall, right, and my mirror's hanging on it. That's still personal property. But if I attach it permanently, then it stays. So if there's any doubt, what do you do as a buyer's agent?
Right up.
Write it in a contract. Any doubt about anything, write it in the contract. Okay?
So
Good.
chandelier is a personal property or
Chandelier is not personal property. It is permanently attached
permanent?
by
Okay,
a
thank you.
licensed title insurance company with no additional risk premium. Okay? Now, good. There's no problems with it. Marketable, free from serious defects, not all defects, okay, and insurable. You can have a deed that is insurable that has an actual problem with the deed, but the insurance company said it's not that serious. We'll just insure over it. If it becomes a problem later, then we'll defend the title. Okay, so they're different. What you need is all three: good, marketable, and insurable by a licensed title insurance company with no additional risk premium. Okay, if there's an additional risk premium, this is an entirely different story, and they will insure over certain things and figure, let's just put the problem off until it becomes a problem in the future. We may never have to defend it. In case action is required to perfect the title, such action must be taken promptly by seller at seller's expense. Okay. In the old days, you remember this contract said if there was a title problem on the day of settlement, then the buyer just had to go away, and sometime in the next 30 days, after we get this straightened out, you come back when we tell you to come. And by the way, this is at your expense, buyer. Remember that? We don't have that anymore. Okay. So the seller has to take care of this, as you know, promptly. Title may be subject to commonly acceptable easements, covenants, conditions, and restrictions of record, if any, as of settlement date. So you need to see what the deed says right up front, right? Easements. What's an easement? Well, there could be an easement across my property for somebody to get to a property that's landlocked, and I can't shut that off. There might be an easement for the county sewer, the storm sewer running through the backyard. There could be an easement for that little green box that they put out there, boxes throughout the neighborhood. There's all kinds of different easements, all right? Covenants and restrictions of record. You remember when we discussed the law changes this year, one of the law changes, illegal to have any restriction in a deed based on fair housing. Okay. Now, when the street I grew up on when I was a young person, after the farm was sold for apartments, we moved over to a street in Bailey's Crossroads, and in the deed it said no blacks and no Jews were allowed to live there. Okay. When I packaged all that up to resell it, okay, to a builder, the builder required that we go and have everybody remove that from their deeds, because even though it wasn't enforceable, it would have gone forward with the deed. Today, they have a corrective deed that you can, or paperwork you can file to remove that from the deed, and it should never transfer forward anymore. Okay? So if the title is not good and marketable and insurable by a licensed title insurance company with no additional risk premium on settlement date, okay, so we've got to wait till settlement date to do this. The buyer may, at buyer's option, declare the contract void in writing, okay, or pursue all available legal and equitable remedies. So legal would be sue for damages, okay, which could be compensatory, punitive, or equitable remedy is called specific performance, okay? Make the seller make it right and deliver the property, okay? Now, unlike before where it said buyer go away, the seller has these options, right? Now, one of the things that I ask all the sellers to do when I list the property, okay? I just ask the seller to do it right up front. Why don't we do a preliminary title search on your property? Okay? Do a preliminary title search. Let's see if there's anything that affects the title now before we put your house on the market. All right? Because if we get a contract that says you have 30 days to go to settlement and they find a title problem, it might take more than 30 days to clear it up, and we're going to put you in a position to be sued for damages. Okay, so maybe we want to check. And people say, well, we lived in the house for 40 years. Okay, there can't be any problem. Well, did they have a mortgage 40 years ago? And did they make payments religiously? And they paid it off, and there was a satisfaction piece sent by the lender to them for them to go to record to show the mortgage had been satisfied? And if it did they go up and record that at the county? Probably not. They probably put it in some box. It's in the attic somewhere, if they could even find it. But now we have this mortgage that's never been released, and it's from 40 years ago. And these people, okay, these people can't find the paperwork. And in worst case, this mortgage company's been sold several times and no one knows where anything is. Well, they can't just, go to settlement. This might be one of those things that the title company would insure over at additional expense. Well, maybe the buyer doesn't want that. So if we know of these problems or something was recorded that wasn't against them, okay, because quite frankly, if somebody gets a judgment against them and they have a name similar to yours, okay, they just put judgments against anybody that has a name that's close. And then you sign those affidavits at the settlement that this was not me, etc. So there's all kinds of things that can pop up that we can clear up right up front before we put the house on the market. Now, most title companies will work with you to do the title search, and not that expensive. And look, we can't say must use our title company as a listing agent, correct? That's against the law, right? Paragraph 3 of the contract, against the law, okay? However, there's nothing to prevent us from putting in our listing a preliminary title search have been, conducted by RTS title, shows no damage, nothing affecting the title. Now everybody might agree to use RTS because all they have to do is bring the title down from that time until settlement. So maybe they'll agree to use the title company, right? So you don't have to do that. It's just something that I ask the sellers to do up front. I want as few problems as we get close to settlement as possible. Okay. Any questions about that?
Even though, Larry, even though they have the first home owner buyer, they're buying only first time they buy. There's no other buyer. No more other titles. just like brand new house.
Oh, brand new house. What kind of deed are they going to get? And that's coming up in the next paragraph. When you buy a brand new house, what kind of deed do you get? You know what it's called?
General deed. Understood.
No, you don't. New home, you don't get a general warranty deed. You're going to get a special warranty deed. And what does a special warranty deed mean? That means during the time I've owned this property, I've done nothing to encumber it. I'm not guaranteeing anybody else didn't or whatever. Okay. So they're getting a special warranty deed. So the builder didn't do anything to encumber it during the time they owned the property, but what about prior? Okay. And I'll discuss that when we get into the next paragraph. Okay.
Thank you.
All right. So here's what the buyer has the options of doing. They can pursue all available legal and equitable remedies. Nothing herein shall prohibit the parties from mutually agreeing to extend settlement date under the terms acceptable by both parties. So we can write up a what? An addendum to the contract, right? Right there at the table. Now, I say, look, this is not my problem. This is your problem. You should have taken care of this, before, okay? So as a buyer, I'm going to say, look outside there. You see that moving van? What do you see out there? There's 2 kids in the front seat. There's 2 dogs. There's, hamster, whatever, okay? And all my stuff. What am I supposed to do with that? Okay? So here's the deal. If you're willing to give me $10,000 cash, okay, not part of this contract, then I will give you an extension for 30 days for you to get this worked out, because I've got to put all my stuff in storage. I've got to find a place for us to live for those 30 days. Is your seller going to want to do that? Maybe not, but that's better than being sued. And if we'd have known about the problems up front, we would have never even been faced with that. But we do have the option to agree. In a competitive market where your buyer had to beat out 4 or 5 other contracts and there's a problem at the end, they will probably be willing to what? They might be nice and say, okay, we'll go forward. Well, I'm going to tell you what, if I got raked over the coals and I had to pay more for a property, okay, I'm not going to be so nice as a buyer at the settlement table. I don't know about you guys, but I'm probably going to be looking to recoup some of that money I had to pay too much for when you had all the aces in the deck. Okay. Now I have them. Okay. So we don't want that problem. Let's solve it before we have a problem, right? So if it's done, if the title work is done right away, well, once again, who orders the title work? Okay. The buyer, and they have 10 days to do it. We may not have that much time to correct a problem. I've preached enough on that. Okay. Now, let's look at the next paragraph. Seller will convey property by general warranty deed. Okay. With English covenants of title. Okay. General warranty deed. Now, a general warranty deed is the type deed most people use, and it gives the greatest protection to the buyer. Greatest protection to the buyer. But as a seller, do I want to guarantee the property for all time? Well, builders and corporations, etc., won't do that, right? Now, when they talk about the English covenants of title, okay, you might remember the bundle of rights theory. So the first one, covenant of season, which means I actually own the property that's being transferred, so I can transfer it. The right to convey, I have the power, the legal capacity to do this. The covenant against encumbrances, there's no undisclosed easements, mortgages, or liens. And you'll see most of this language is built into this paragraph, okay? The covenant of quiet enjoyment, okay? That doesn't mean that the neighbors aren't noisy, right? That means that once I give you possession of that property at settlement, you have the right to live in peace, undisturbed by any unlawful claims by a third party. Okay? The covenant of further assurance, if I have to help you do anything to correct the title afterwards, I will do it. But the final one, okay, covenant of warranty forever. The promise that the grantor will defend the buyer's title against any claims superior to that buyer's title that existed before the conveyance was made. So I'm guaranteeing, when I give you a general warranty deed, I'm guaranteeing that property against all time.
Larry,
Okay.
which paragraph is that?
Do what?
What number are you reading?
I'm just telling you what Principles of Real Estate says about the English covenants of title. But I'm in paragraph 20, where it says, the third paragraph where it says English covenants of title.
Thank you.
I don't think anybody would ever turn to you and say, what is that? But if they are, they're the 6 things that I just told you. They're called the bundles of rights. And in Virginia, with a general warranty deed, you are guaranteeing all those. With a special warranty deed, you're guaranteeing all those except for against all time. Okay. So if your buyer bought a new home, right, and they got a special warranty deed, and now they're selling the home and I'm buying it, this contract is telling them they have to what? They have to guarantee it not only during the time they owned it, but prior to anything prior to that. Okay. Now, they went to settlement. They were given the option of having owner's title insurance, right? And they decided they didn't want to spend the money on it. That is the worst decision they could ever make. Don't ever let your people do that without objecting. Never tell them they don't need it, okay? Because what that title insurance will do is cover the claims against all time, okay? So if something comes up in the future, even after they don't own the property anymore, if they had the title insurance on the property when they owned it, the owner title insurance, not the lender title, right? Then they will defend the title. But if not, man, that special warranty, converting it over to a general warranty, and I'm going to guarantee it against all time, I'm not sure that's what I want to do. Now, how many agents are ever going to explain that to a seller? Not a whole lot. Okay. And that's why this next sentence says, buyer is advised to seek the appropriate professional advice concerning the matter of taking title. Okay, yes.
Would you explain one more time the English covenant, please?
The English covenants are things that are guaranteed, implied guaranteed by our law, unless they are spelled out individually. So there, you could Google warranty deeds, and they're included in a general warranty deed, right? So season just says covenant of season, just simply says, I actually own the property, I can sell it. Okay. The right to convey, I'm legally capable of conveying. I may have a power of attorney for someone to sell their property. Okay. The big one is, though, the covenant of enjoyment, that if anybody comes back in the future to sue me because there was a flaw in your title, then you're going to have to defend it and make it right. That's why you want that owner title insurance, right? But the biggest one of all of those is the warranty forever. Under a general warranty deed, I'm guaranteeing this for all time, prior to when I owned it, okay, from the time it was dirt. Okay. Good. So, buyer is advised appropriate professional advice concerning the manner of taking title. I would discuss, at the table, special warranty, general warranty, but also Do they want it tenants in common, tenants, joint tenants, tenants by the entireties? This should all be discussed with them. We can't give legal advice. If you're married in Virginia and it's tenants by the entirety, anything happens to one party, it automatically goes to the other. Joint tenants, people aren't married can be joint tenants with the right of survivorship. So it would go directly to the other party. Tenants in common, then basically something happens to one party, then their heirs step in their place. So they really need to discuss the intent of this, especially when there's second marriages involved, et cetera, and people trying to make sure their kids are, taken care of, et cetera. So we don't give that advice. The attorneys can answer those questions and give that advice, right? Any questions about any of that to this point? Okay. Seller will sign such affidavits, lien waivers, tax certifications, and other documents as may be required by the lender, title insurance company, settlement agent, or government authority, and authorizes a settlement agent to obtain a payoff or assumption information from any existing lenders. Don't forget to ask them when you list the property, do you have any HELOCs, home equity lines of credit? People have used HELOCs to buy cars because the interest rate was cheaper, or pay for college, etc. That is nothing but a second trust, and it has to be paid off at settlement. That is not something they take with them and keep making payments on. So first trust, second trust, HELOC is nothing but a second trust, and it's going to be paid off at settlement. And a lot of times they're shocked when they get there, thinking they would have the money to go buy the new house and still make payments on that HELOC. Doesn't work that way. Okay. Now, it says seller will pay any special assessments and will comply with all orders or notices of violations of any county or local authority, condominium unit owners association, homeowners or property owners association, or actions in any court on account thereof against or affecting property on settlement date. So we've discussed this before. If there's a violation in the condo docs, okay, the seller has to fix it, okay? If they don't fix it on the day of settlement, it survives the contract and we can go back and sue afterwards. It's not a reason for the buyer to not go through with settlement, okay? But the seller is responsible for that. We don't have to write a written addendum. We just send a notice over saying, in accordance with paragraph 20, we want you to be aware that this was in the documents and, expect to be taken care of, right? Now, the special assessments can cause a problem. If it's something they're thinking about having a special assessment for, in a condo, for instance, like one condo project, we're thinking about replacing all the patios and all the all the way up the building, okay? They hadn't made the decision yet. So there was no assessment in place before settlement. And the assessment's made afterwards, and everybody said, we should have told us about that. Well, it was in the documents, you should have read it. However, if the assessment is made prior, okay, to settlement, then the seller's responsible. Well, what if it's going to be made in payments over 5 years? Okay, well, now you guys have got to work that one out. But technically, since it was already an assessment, the seller would be responsible for all of it. However, it might be something you want to negotiate, and the buyer will take over those payments, etc. Pay close attention to this paragraph. And orders or notices of violations of any county or local authority. Remember, unless there's a written notice of a violation of the zoning law or safety statute in the state of Virginia, then the buyer is going to be on their own. The seller doesn't have to tell them. So the example I always give, the unfinished basement that is now finished, there were no permits pulled. There was electric and plumbing done. The buyer settles on the property. No one's ever told them. The county somehow finds out that this work had been done. A notice, like the agent talks about the completely finished basement, and they somehow see that listing, which can happen. And all of a sudden they send a notice out of violation to the new buyer. Hey, we don't have any record of permits. You need to apply for the permits. So they do, and now they're told, now you take your walls down so we can come and inspect the plumbing and the electric. Your buyer is going to be all upset. You're going to be calling the listing agent saying, why didn't you tell us this? Okay, why didn't the seller disclose? We're going to sue. I don't see how you can sue a seller. There was no written notice or order of violation. Okay, so once again, where do I go to have my buyer check all that out? Well, in Fairfax County, we would go to FIDO, Fairfax Inspection Database Operations. You can Google that, FIDO. You can put the property address in. We'll show if there's ever been any permits pulled and finalized for work. If not, and that basement is finished and it shouldn't be, I am going to be having my buyer either write in a contract that is contingent upon the seller providing the permits and the occupancy for it, or they're going to sign that adverse consequences form that I've told them they really should check this out and have the seller provide it, and they've decided to go forward without it. Okay. And we put in here a hold harmless. Broker is hereby expressly released from all liability for damages by reason of any defect in the title. Okay. I would recommend that, pay special attention to that one. That's our hold harmless and protects us. Okay. I want you to go, if you would find paragraph 38 in your contract package, page 12. Okay. Paragraph 38 talks about the entire agreement. Okay. In the second sentence of that, the provisions not satisfied at settlement will survive the delivery of the deed and will not be merged therein. And that's very important language, because when we go back here and it says we'll comply with all orders and notices of violations or condominium owners association, etc. If this stuff was in effect at the time and it was not corrected, just because we settled doesn't mean it goes away and the seller doesn't have to do it. Okay, it's still protected under paragraph 38. It survives the settlement of the deed. Paragraph 26 says you have the right to sue for a breach buyer, and if you win, you get all your attorney fees, etc. So paragraph 38 is the protection for things that are not completed at settlement. Any questions? That's a lot to be thrown at you at one time, I realize. Any questions anybody wants to ask about anything else before we call it a day here? And remember, Mondays at 11, Ask Larry. I'll be there for Ask Larry. And next week we'll pick up and cover paragraphs 21 through 24 of the contract on Wednesday.
Larry, can I ask you a question?
Sure.
I put an offer yesterday and we got they accounted back for 528. And then I talked to my client confirmed it was in the text. And the other agent accepted And after that, 2-3 hours, she couldn't pick up the phone. And at 6 o'clock, she takes me back. I'm sorry, we take another contract. Mine was cash. It was closed fast and everything. She likes it. And then at 6 o'clock, they said another contract came above the asking price, and they accept the other one. Is that okay? Is that why
Well,
should I?
that one your buyer would need to talk to an attorney to see it. It's still, a jury's still out on whether or not an email or a text saying we accept it. My opinion, they probably had ratified a contract, had the listing agent acknowledged your text
Yes,
that your person had accepted it.
yes.
Then I would probably talk to an attorney and see if they want to proceed. They may very well have had a contract, but that's something a judge would have to decide. So would they be willing to spend that much money to find out?
No. They
Okay.
don't.
No,
But it's not right, right? It's
No,
not
it's
supposed
not.
to be that way.
No, it's not right. What did it say in paragraph 6 for delivery for the seller? Did it have the information of the listing agent there, or did it have the seller's information?
Both of them. But the problem is,
Okay.
it didn't, when I sent the offer, I sent it in the night before. And she said, I was calling and it said, I haven't found a seller yet. And
Okay.
in the morning it said, give me 5 minutes, another 5 minutes. I think she was just buying the time to get another offers. And
Well, she may have been, but there's no way to know.
yeah,
So unless
nothing was signed or nothing was, it just in the text, it was a offer and counter and acceptance. That's all.
yeah. I mean, I'm not sure that I'd want to spend the money to see if if we could
Exactly.
hold them. I think that probably could, but once again, they're going to have to get an attorney to give them that advice.
Thank you. I know.
Okay.
I appreciate it. Thank you so much, Larry.
Okay. Any other questions
Larry.
today? Yes.
Mr. Anderson, I need to ask you, please. Who's supposed to write the date on the date of ratification? Who's supposed to write
Whoever
last person?
whoever sends the last notice over, it says here that it's ratification is when it's delivered to the last party. Okay. So if I send it by email, I'm the listing agent, right? And my seller just initialed the last change, then I am sending that over to you by email, if that's what it said in paragraph 6. At that point, we have ratification. I will then probably fill in the ratification box itself and resend it. But technically, once you can prove it was sent, that ratification date is done. So the last party that sends the last thing to the other party is delivered, fill the box in.
Thank you.
Okay?
Larry, another question, please.
Okay?
You mentioned when you were covering the potential issues in title, you mentioned the bundle of rights in Virginia that pertain to Virginia.
Yes.
Where can I have a look at those?
Just Google general warranty deed.
Okay.
Okay? And the bundle of rights will be included in a general warranty deed. So you should be able to find them.
Okay.
Or just put, or just put covenants, the deed covenants.
Okay.
Okay.
Thank you.
Okay.
Larry,
Yes.
this is Ismat. I have 2 questions outside of this class. It's okay?
Okay.
First one, as a matter of fact, I took the CE class and I took the exam a couple of days ago. I passed, but 2 questions very confusing. I thought I answered them wrong. One is about agent Andy is acting as agent of the landlord in finding tenants for the landlord. The landlord has accepted lease application from a prospective tenant, but the tenant has not yet taken possession of the unit. Another prospective tenant present Andy with an application to lease the unit, same unit. Andy would be required to present the application to the landlord.
Yes.
A, under no circumstances. B, under all circumstances. C, only if agreed to as part of the brokerage agreement. D, up until 5 days prior to closing.
You have to present all leases and all contracts to the landlord or to a seller up until settlement unless otherwise agreed to in writing in your agreement with the landlord.
So the answer will be D.
Well, whatever.
Yeah, until 5 days, business days.
It's got
prior
nothing to do with 5 days up until the time of the
of closing.
ratification, up until settlement. Our statute says settlement. Okay. Unless
Okay.
otherwise agreed to in writing by the client.
So it's not only if agreed to as part of the brokerage
As
agreement.
the agreement, yes.
Is this the answer?
I would think so.
Yeah. Okay. Yeah. And
But
the other.
ask me these Monday when we do the Ask Larry, okay? Because we're supposed to be just covering this contract today. So I'm going to put off the other questions until then because people are going to be watching this. It's being recorded. They're going to watch it for the contract portion.
Okay. Okay. Thank you.
Okay.
Thank you. Okay.
So thank you guys for joining me. I'll see you guys Monday when we do Ask Larry.